And you got Harrington here, folks. All right, back from Spain, still a little gimpy, but in my assigned seat. Today I want to talk to you contractors. I'm talking about you general contractors, you plumbers, you electricians, you roofers, you gutterers, pool installers, you guys. The reason I want to talk to you is because I see disputes being tough on you guys sometimes. And look, of course, the complaints go both directions. The owners or the GCs say, you were late, you used the wrong materials, you did crappy work, whatever. So I'm, no judgment there. I get that the arguments go both directions, but the person doing the hiring somehow seems to have a little bit of a built-in advantage sometimes in that they can withhold payment. So what I tend to see in my practice is the contractors getting beat up in these disputes, and I'll explain why. So let's just get into it. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1, the problem. Okay, now again, disclaimer, I understand there are arguments both directions, and I'm sure both sides are right and wrong at some point, but just based on what I hear from my clients and what I kind of think I observe, here's the problem. You're a contractor, you've done some work, and now the party that hired you doesn't want to pay. So you've already been beat for several thousands of dollars, probably, and that's tough on you because you've paid for materials, you've paid other people to do work, you've got your expenses you still have to pay, but you're not getting paid. So what are you supposed to do? I mean, you're supposed to take it to the courts, right? What else can you do, really, other than grab a bat? But we're not going to do that. No frontier justice. Okay, but how great of an option is that to you? Now you got to pay me. You're already out the money that you advanced on behalf of the client. You don't have the money the client was supposed to pay you. And the client has the right to due process. So what does that mean? That means they can file their answers and affirmative defenses. They can bring a counterclaim against you. They can make the case long and expensive. This, I can tell you from experience, is very frustrating for you. You want the case to be simple because in your mind it is very simple. You've been beaten. This person is a jackass. You don't want your attorney asking you for more and more money because the case is getting longer and more complex. You just want your damn money. All right, I get it. Part 2. Right, so that's the problem. What are we going to do about it? Okay, part 2 is paperwork, but stand by. Let me first say, you are men and women of action. You're not necessarily paperwork people. In my youth, I did some carpentry, really framing. I worked as an auto mechanic. I tented homes for fumigation. My father's an inspector. Listen, my whole family's blue collar, so I think I get it. I understand where you're coming from. I'm not going to try and turn you into, English professors who are all about the paperwork. I understand that you don't want to do that, and you're not good at it. Let me do this to try and be helpful. Let me just tell you the minimum that you need to do that is going to change everything. It's going to put you in such a better position legally. It's going to make all the difference. And why do I say that? Because, look, don't forget, the judge. What are you expecting from the judge? The judge wasn't there. He doesn't know who's lying. So you get to court, you got the he said, you got the she said. You're going to find yourself going, wow, is this person really going to stand there and just lie in court? Well, first of all, lying is very subjective. People remember things the way they want to remember things. And at a minimum, they're going to put a little spin on the truth. And let's just face it, sometimes people are just going to lie. And what are you expecting from the judge? The judge doesn't know who's lying. Oh, and here's the worst thing. If at the end of the evidence, the judge it's a tie, like neither one of you has much paperwork and it's just one person saying the other person is full of crap. What do you think the judge is going to do? You lose because you're the plaintiff and you have the burden of proof. So if you guys come up even, you lose. So just very briefly, because I know you've heard this before, obviously you have to have a contract, but there's a little more to it than that. Don't just have any contract, have a really good contract, one that's well prepared. There's so many protections you can put in there. And the client they're just like you. They don't like to read all the fine print. They're going to sign it. So what am I talking about? Well, mainly the attorney's fees, right? You want to make sure that by the time you go through the painful process of litigating and paying your lawyer and you go all the way through the end, you want to make sure that when you win that case, you get everything back. Not only the money that's owed to you, but the attorney's fees and the cost of the litigation. Actually, it's a good time to make this point. So if you don't have a contract, you can still sue. You can use what's called quantum meruit or unjust enrichment. There are some theories by which you can still recover but you're not going to get attorney's fees. You're only going to get what the client owes you. And that's a bad situation to be in, because that means that the client has nothing to lose, right? The worst that can happen to them is that they're going to pay what they had to pay anyway. So contracts, that's an obvious one. And then change orders too, right? Because the change orders actually form a part of the contract. And then you don't have to, okay, look, we know how it goes down, right? So you get into a job and then you see wood rot that what you weren't expecting to find, or there's a bad pipe there or whatever. And the client just comes up to you on the side and says, well, you know what, now that we're in here, let's just go ahead and do that work. Well, that's a change order. But only you and the client know that that extra work was requested unless you put it on paper. What about delays? Well, a lot of times you know that there's a delay because the client didn't give you the deposit, right? But only you guys know that. How about you send a really quick letter, or you pay me, probably. It's going to be a couple $100, but you're going to be in a great position to defend yourself should you need to. I send out a quick letter saying, dear client, we understand circumstances arise. According to the contract, you were supposed to give us a deposit by such and such a date. Didn't happen. That's okay. We're going to stand down in the meanwhile until we get that money. Boom. Now you have something you can present to the judge. And the judge doesn't have to have the client saying, well, they just took weeks and weeks and they didn't do the job. And you're saying, well, I didn't do the job because they didn't give me the money. And the judge doesn't know who's lying. Now we got a little piece of paper and the judge knows. So that's about it. That's all I'm going to say. Okay, guys, let's keep it simple. Paperwork. All right. Initial contract, change orders, and then the occasional letters, the notices, depending upon situations that come up along the way. That's it. Just do that. Just, pay me to do that part. It's not going to be a big expense. And then you're going to be rock solid in the event of non-payment. Part 3, I got one more suggestion for you, and it's this. Let's try to stay out of the courts. Now, look, this is a bit of a controversial take. You're going to find other attorneys who disagree with me about this, but statistically, arbitration is much faster and much cheaper than litigation. I'll throw out a quick disclaimer. It does make a difference who the arbitrator is, how professional and how, diligent he or she is. It can make a difference whether the attorneys are taking the whole thing seriously or not. I haven't had this situation, but I've had arbitrators tell me, sometimes neither attorney meets a deadline. And then what am I supposed to do? Right? Dismiss the case? Well, that just punishes the plaintiff. That doesn't seem fair. So then things get delayed and, okay. So there are circumstances that can arise, but if we're looking for solutions, that's one potential solution. Let's make sure that in our initial contract, we have an arbitration clause that says, in the event of a dispute, we're not going to the courthouse, we're going into arbitration. And by and large, we can expect that process is going to be simpler, faster, and cheaper. So that's what I've got for you people. I mean, look, I feel your pain. I do see you in these bad situations sometimes. And we know that there are some jackasses out there that can be predatory. They can use this withholding payment strategically. But protecting yourself is not that hard. If we boil it down to just the minimum that you just must do to not be abused and taken advantage of, then it comes down to minimal paperwork, contract, change orders, occasional notices, and then make sure that you have an arbitration clause in place so you can stay out of the courts. It does break my heart sometimes to see you hardworking contractors, and I know, I've been out there under the sun, I know, get taken advantage of. So let's try to avoid that. Okay, recuerda que hablamos español. You already know what you got to do down there with the comments and the likes and all that. Please give me a hand here. And I will see you guys next week.